Okay, well, kia ora everyone. Welcome to the webinar Navigating the Health Information Privacy Code in the Context of Research Ethics Applications. I'm Dana Wensley, and I can't see how many people are here, but I gather there's quite a few of you. So welcome and thank you for giving me your hour to look at the Health Information Privacy Code and what we do as ethics committees to navigate that. Ko te pukioni tuku manga, ko Waikura Pupu Tupuna, no Motueka Aho, ko Tamaki Makaro tuku kainga, ko Dana tuku ingoa, ko Wensley tuku whanau. So the aim of the webinar is to explore and demystify the role of research ethics committees and their relationship to access and data under the Health Information Privacy Code. I'll look at the interaction between research ethics committees and obligations under the code, and I'll explain some points for researchers to help them navigate their dual responsibilities that span ethical and legal obligations. The webinar will highlight through the use of some real world examples the red flags and pitfalls applicants make in their research ethics submissions. And the webinar will support and uplift understanding of the ethics committee process and show respect for patient data in keeping with ethical obligations. Now, a little bit about me. I started my professional life as a registered nurse at Green Lane Hospital. I then went on and got a law degree at University of Auckland, a master's in medical law and ethics, and then a PhD in medical law and ethics at King's College London. Now, my PhD was in looking at genetic testing and the use of genetic data in the context of prenatal screening and pre-implantation diagnosis. And that was way back in the time of the sequencing of the human genome. I served for 6 years on the National Ethics Advisory Committee as a key contributor to the standards, which we're going to be talking about later on in this webinar. And I currently manage the Human Participant Ethics Committees at the University of Auckland. These are institutional ethics committees established and supported by the University of Auckland. So we review around 900 full applications a year, not including amendments, and so it's quite a busy workload that we have. We see a lot of applications, and I'll be drawing on some of the information in those applications while maintaining obviously privacy and confidentiality. Just give examples of the pitfalls and some tips that researchers can use when they are submitting ethics applications. We have two main committees. The first one is the Auckland Health Research Ethics Committee. Now that reviews health research and health-related research and not eligible for review by the Health and Disability Ethics Committees. For those of you that don't know, the Health and Disability Ethics Committees are managed by the Ministry of Health and sit outside of the institutional ethics committees. So we see applications from university members and also staff from the four northern regions of Te Whara Ora. So we see Te Toka Tomai applications, counties Manukau, Waitemata and Te Tai Tokoro. The other committees that we manage are the Human Participant Ethics Committees, which are more social sciences research that comes from the arts, education, engineering, business, and law backgrounds. Now, what we are seeing is applications from researchers wanting to access health data from a variety of sources, either public or private databases. And increasingly, these are applications for access to large data sets which can contain thousands of patient notes, blood tests, radiology reports, and increasingly images. These types of applications are swiftly becoming a significant part of the Ethics Committee work, and these are areas where we have noticed some differing views emerging across the ethics ecosystem around the responsibilities of researchers and the role of the health agency in releasing the data and the role of the ethics committees. Hence the reason for this webinar. And I hope to clarify some of those different roles that exist under the Health Information Privacy Code. So, health information is one of the most sensitive types of personal information. For this reason, it has extra protections around its handling, hence the specific provisions set out in the Health Information Privacy Code. My interest is in the role of ethics committees in the protection of health information, as they play a crucial but often under examined role in safeguarding of information, in which I call is a hybrid model that exists in Aotearoa between ethical and legal obligations. And I'll be explaining this hybrid model more fully in subsequent slides. Before I do so, I want to touch briefly on the inquiry last year that looked at how government agencies protected personal information for the 2023 census and COVID-19 vaccination purposes. The report was released in December 2024 and it contains this quote, which I think is incredibly poignant for our purposes and discussion today. It says the information has power. In the case of an individual, their personal information is their whakapapa, past and present. It tells a story about where they've come from and where they're going to. It is their story, it is their information to give and to share. Now, the inquiry mentioned two agencies relevant to the discussion today, the Ministry of Health and Te Whāra Ora. The Ministry of Health supplied personal information to the relevant service providers for COVID-19 vaccination purposes, and Te Whāra Ora had data sharing arrangements in place with the relevant service providers. Excuse me. Now, the findings were that the agencies did not implement a systemic means for assuring themselves that the relevant service providers were meeting their contractual expectations, and the generic data sharing agreement framework relied on a high trust model and commercial incentives as safeguards. The Ministry of Health and Te Whāra Ora had limited safeguards in place for identifying and managing the possibility of conflicts of interest arising from the sharing of personal health information with the relevant service providers. Now, I understand there's significant work underway to revise the data sharing agreements and to take account of the recommendations from the inquiry. The inquiry demonstrated to me, though, that some additional safeguards were required to protect health information in some contexts. And I asked myself, was this a wake up call for us to consider the checks and balances around sharing of information in the context of research? It certainly made me think more carefully about the role ethics committees play and seek further clarification and discussion around the oversight ethics committees are expected to provide in the hybrid model, which I'll explain later. Now, this is obviously a wider discussion to be had by a range of stakeholders, but I raise this here as it's a timely reminder that as our ability to collect, access, and disclose data becomes more sophisticated, so too do our mechanisms for protection of that data need to evolve to keep up. So, why discuss this now? Well, what we're seeing is a shift in research focus away from one or a couple of clinicians or practitioners dealing with a finite group of patients or patient files to studies that use large data sets made up of existing health data. We see a rise in computer power and increased focus on large data sets, big data analytics to solve issues at the intersection of health, well-being, and society. We also see a large number of data banks and unofficial collections of data gathered previously, sometimes with informal data sharing arrangements where there's little or no data governance structure. And some of these are from persons in dual roles, for instance, a clinician and a researcher role wearing both hats in that example. We see the application of Maori research ethics principles such as Te Aratika principles and new considerations of Indigenous collective views to the right to privacy. And also the risk of re-identification is amplified by merging multiple data sets and the power of new techniques that make most data potentially identifiable. One thing we see also is an increase in applications where there's an aspect of commercialization, and in some instances, applicants or principal investigators are part of companies that have a very complex corporate structure. Now, we can anticipate an increase in these types of private public partnerships as a means to drive innovation in the future. And while an ethics committee is able to assess the ethical risks and benefits in this, some applications don't sufficiently describe these relationships, which makes providing research ethics approval quite complex. And that can, of course, cause delays in the processing of applications because, as we'll see, the ethics committees do need to know what is intended in the project before they can approve the application, especially if a researcher is asking for what is called a waiver of consent. Now, a waiver of consent, for those of you not involved in research ethics, is when a researcher asks the ethics committee to waiver the need for the researcher to consent each participant before their data is used in the project. Now, while consent is a gold standard to any release of health data, there does exist some instances when an ethics committee can approve a study which enables the researcher to use health data without the consent of participants involved. And this can sometimes be hundreds or even thousands of people's data. And in a later slide, I'll explain under what conditions this waiver will be provided by ethics committees. So against this background, I will describe in the next few slides the intersection of the Health Information Privacy Code and the role of ethics committees. But before I do, I want to give you a real world example to highlight some of these challenges. Now, last year, the privacy watchdog in Australia announced it was looking into a partnership between Australia's largest radiology chain and a startup involving the use of patient data to train AI. The Office of the Privacy Commissioner confirmed it had launched a preliminary investigation over the transfer of data to the startup. The company was called Harrison AI. Now, the founders launched Harrison AI in 2018 and partnered with iMed, which is the third largest private network of radiology clinics in the world, to create a comprehensive AI supported radiology platform. The first AI offering from this partnership was called Analyze Enterprise. And to show the fast moving pace of this technology and the incredible power of these partnerships, Analyze Enterprise was developed and commercialized within 18 months, and it was swiftly made available to 50% of radiologists in Australia and clinics across Europe, the UK, Middle East, and the United States. Now, in a study published in the journal European Radiology, the authors set out the results of the trials, and it showed they used a subset of data from approximately 170,000 people's unique files used to train the AI. No informed consent from participants whose data was used was provided. But multiple review boards, that's ethics committees equivalent in Australia, at different levels provided the waiver of consent. Now, this provides an example of the type of research we expect to see in the future with potentially significant benefits in healthcare. It's decisions like this that are now falling to ethics committees who play a crucial but often unclear role in privacy protections. Interesting research by Angela Ballantyne and Andrew Moore, published in a 2018 article, looked at how ethics committees make these decisions and found that ethics committee members felt a weight of responsibility in this space to juggle competing interests. So on that note, it's timely to turn to look at the Health Information Privacy Code itself and the role of ethics committees and see what it says. So looking specifically now at the Health Information Privacy Code, we see that it sets out provisions for the handling of information for research purposes. The research ethics committees are mentioned in the code in four main areas. In Rule 2, that's the source of health information. In Rule 10, the limits on use of health information. Rule 11, limits on disclosure of health information. And in the Schedule 3, secondary use of newborn babies' blood samples. Now, this is called the research exemption by Professor Skegg in his 1996 guidance notes for ethics committees and researchers. This exception is used where it is impracticable for researchers to obtain individuals' consent. When considering applications to use data without gaining consent, research ethics committees have a role to balance the need to protect health information and the important role of health and medical research in advancing public health. Now, of note, in Australia, the Privacy Commissioner has approved two sets of legally binding guidelines issued by the National Health and Medical Research Council. Researchers must follow those guidelines when handling health information for research purposes without an individual's consent. And the guidelines also assist the Human Research Ethics Committees in deciding whether to approve research ethics applications. So now we turn to the question of what do I mean when I say ethics committees? I've touched on that, but I'll explain it a little bit more who's involved in the deliberations, how the decisions are made, and what factors are taken into account. The first thing to note is that Health Information Privacy Code defines ethics committees as the Ethics Committee of the Health Research Council of New Zealand, or an ethics committee approved by that committee, or the National Advisory Committee on Health and Disability Services, or an ethics committee required to operate in accordance with the currently applicable operational standard for ethics committees, which I'll talk about later, or an ethics committee established by or pursuant to any enactment. Now, the committees I manage are the ones approved by the Health Research Council Ethics Committee. They're called institutional ethics committees, and they exist in most tertiary institutions to support their researchers in complying with required ethical standards. Rule 4.5 of the Health Research Council approval guidelines requires that institutional ethics committees have policies and procedures in place to ensure that committees are applying the highest national and internationally accepted standards for the conduct of research. These committees are accredited by the Health Research Council. They're required to provide yearly annual reports and apply for re-accreditation every 3 years. For our purposes, it's interesting to note that Rule 2.1.6 of the Health Research Council Ethics Guidelines provides that the privacy and confidentiality of research participants must be respected. In particular, ethics committees have to be familiar with the Privacy Act and the Health Information Privacy Code when examining precautions taken to safeguard the privacy and confidentiality of research participants. So these institutional ethics committees, who sits on them? So they're actually very tightly monitored by the Health Research Council. They must be large enough to ensure that a range of perspectives and experience and expertise are represented in the ethical review. Where relevant, members should include individuals with experience and expertise in Te Reo Māori and the understanding of tikanga Māori, ethical moral reasoning, law, the perspectives of the wider community and consumers, the design and conduct and observation of intervention studies or other expertise is required. Membership is strictly monitored and we have to report on that every year. Lay members form an important part of New Zealand's ethics ecosystem to the extent that the institutional ethics committees are required to have a lay member as the chair. Now, I have put a snippet of an article there for those interested about the role of lay members on the committees. They are incredibly useful because they make sure that the decision of the ethics committee aligns with the views of the wider community. In New Zealand, ethics committees must follow the guidelines set out in the National Ethics Advisory Committee guidelines, which is the snippet of that is on the right-hand side of the screen. The National Ethics Advisory Committee, or NEAC, is known as a ministerial advisory committee established in 2001. under New Zealand legislation, now under Section 92 of the Paiora Healthy Futures Act. And I sat on that for 6 years at the time that we wrote the guidelines that are now in existence, and they were published in 2019. These guidelines set out the minimum standards that researchers must meet when undertaking health and disability research, and they are currently going through a refresh. The other main ethical guidelines that committees must comply with are the World Medical Association's Declarations of Helsinki. The Declaration of Helsinki is a statement of ethical principles for medical research, including research involving identifiable human material or data. Now, that was updated recently in 2024, and there were new standards and guidelines put in place in relation to data, most specifically data banks and biobanks. So let's turn to look at the specific requirements of the Health Information Privacy Code. We'll start with Rule 2. In Rule 2, we see the role of the ethics committees in establishing health information, in enabling, health information to be collected for research purposes other than from the individual concerned, if approved by the ethics committee. Now, this has a proviso that we'll see a recurring theme of the code is that there's a proviso that this can be approved as long as it will not be published in a form that could reasonably be expected to identify the individual. Now, Professor Peter Skegg, in a paper on the Health Information Privacy Code published in 1996, Human Rights Law and Practice, which is still applicable today, gives examples of where an ethics committee may be justified in approving such a collection. He divides these into 3 categories of scientific, practical, and ethical reasons. Examples he provides are if a researcher proposes to collect personal information from a relative or someone else without the authority of the individual concerned because the individual is either deceased, untraceable, incapacitated, or for some other reason. These reasons need to be clearly explained to the Ethics Committee before such approval for the collection of data can be granted. And the Ethics Committee in these cases will weigh up all of the competing interests and the potential public good versus any harm from loss of privacy. So let's look at the use of information that is set out in Rule 10 of the Health Information Privacy Code. So Rule 10 talks about limits on the use of health information. We see here the research exception again, which enables information collected for one purpose to be used for another, so long as Ethics Committee approval has been sought. Now note the words here, if required in relation to the Ethics Committee. That's something we're going to talk about a little bit later. In my experience, it's one of the significant pain points felt by researchers at the moment, particularly on the boundary between clinical audit, quality improvement, quality assurance, and observational studies. So moving to look at the disclosure of information. Rule 11 sets out the rules for disclosure of information. We see again here the research exception, which enables information to be disclosed for research purposes so long as Ethics Committee approval has been sought. And noted again the words if required in relation to the Ethics Committee role. So I want to dive a little bit deeper into this. Just trying to move this somewhere. Trying to dive a little bit deeper into Rule 11. It develops, in my mind, a type of partnership model with the health agency and the ethics committee. There's 2 steps in this rule. The first is that the health agency must make a first determination on whether non-compliance is justified on reasonable grounds because it is not desirable or not practicable. And the second is the ethics committee looks at the application and approves the application on its ethical merits. So how are these two steps operationalized across the research ethics ecosystem? I suspect the exact process may vary in some instances, but in the case of most ethics committees, they would seek information from the researcher that they have gained the relevant organization approval, that's step one, to release data to the researcher, and then the ethics committee will consider their ethical obligations under step two. Now, the health agency is defined in the code, and note that the organizational approval required in this assessment would ideally be prior to the ethical review and is distinct from what is called locality approval. No, locality review is the process by which a locality assesses its suitability for the safe and effective conduct of a study. If a locality is satisfied, then this is the case, then it authorizes the study. A locality is usually an organization from which the research is to be conducted, usually a hospital, a health centre, surgery, or other establishment or facility in New Zealand. Now, you've probably picked up that these rules talk about the identifiability of persons in any publication. It's worthwhile emphasizing at this point that pursuant to Rule 4 of the Health Information Privacy Code, it only applies to identifiable information. The exact wording of Rule 4 is the code applies to the following information or classes of information about an identifiable individual. It does not apply to de-identified health information. Now, I've put up a snippet of an article here that is quite interesting for those of you interested in the issue of de-identified data and the potential for it to be re-identified using modern computational techniques. This study looked at analysis of histopathology images, and it found that even relatively simple deep learning algorithms could re-identify patients in large histopathology datasets with substantial accuracy. So, an emerging area of attention for ethics committees is the realization that it is increasingly difficult to say with any certainty what is identifiable and what is de-identified. The potential for re-identification is one that ethics committees are beginning to grapple with, as deep learning algorithms have increased the potential to re-identify people from what were thought to be de-identified datasets. And it might be good at this point to talk about the difference between structured and unstructured data. The increasingly health data research will use patient data stored in electronic health records, and this can either be structured or unstructured. Structured data are organized using a code set of predefined clinical concepts related to relevant observations, diagnosis, or treatments. And these types of data can be easily de-identified, formatted into databases, and potentially used statistically at quite a large scale. But this can be compared with unstructured medical data, or called free text, which is clinical information written in words more like a narrative. Now, the results of a citizens' jury in the UK, which took place over 3 days, so it was quite an intensive piece of research, showed a high level of support for the sharing of data, even health information data, but less so when it was free text or unstructured text. Now, of course, free text is a rich source of information for medical research, and the intention of this discussion is not to suggest we restrict research to structured data. It is merely to clarify that as technology and computational methods grow, so too should our consideration of whether the legal and ethical responses need to evolve. Now, those of you who are putting in research ethics applications will probably want to know exactly what ethics committees will consider as identifiable, de-identified, or anonymized. Now, I would suggest you look at the National Ethics Advisory Committee guidelines because they have a lot of very detailed instruction on this. I've put this slide up here and the subsequent slide, we will be sharing the slides, so you'll be able to have a look at this later, to just show you where we're currently at in terms of the Ethics Committee guidance of what is identifiable, what is de-identified, and what is anonymized. A precise definition of anonymized data has become more difficult because of methods to re-identify data that are evolving. And according to the National Ethics Advisory Committee guidelines, researchers should assume that all data is potentially re-identifiable and maintain governance and guardianship to that standard. Now, I want to look here at something that's sometimes often overlooked, which is just the distinction between using data for statistical purposes and using it for research. Note there is a section in the Health Information Privacy Code relating to using data for statistical purposes that does not involve ethics committees in terms of oversight. So as we've seen, Rule 2, Rule 10 and Rule 11 all contain the exception for research purposes with approval by an ethics committee. But identifiable data can be used for statistical purposes without the need for ethics committee approval, with the proviso that we're seeing as a common theme throughout the code is that it will not be published in a form that could reasonably be expected to identify the individual concerned. Something else I wanted to point out is the eligibility screening guidelines contained in the National Ethics Advisory Committee standards. Rule 7.5.a says that researchers may review clinical notes and previously completed standard of care diagnostic tests prior to obtaining consent, and that means consent and approval from the Ethics Committee for the purposes of eligibility screening. I would advise you, though, to check carefully with your research ethics office before relying on that, because what we see is a little bit of a drift and a shift in that space. And it is always important to make sure you don't start any research until you actually get your ethics approval. So please do reach out to your research office if you're part of the Te Whāora Ora, or if you're part of an institution, university, reach out to your ethics team to make sure that you don't in any way start research before you have the research ethics approval. So I want to look now at what does ethics committee, if required, mean, which is in Rule 2, 10 and 11 of the code. First thing is that publication does not mean an activity is classified as research. Publication does not make it a more than minimal risk activity, and publication does not alone trigger specific requirement for Ethics Committee review. That is all set out in the National Ethics Advisory Committee guidelines. Ethics approval from an approved committee is required to provide coverage of participants in a clinical trial who sustain injury under the Accident Compensation Act, or to use or disclose health information for research purposes under the Health Information Privacy Code, which is what we're discussing, or to allow the use of human tissue for research under the Human Tissue Act, or for every application approved for funding by the Health Research Council. One pain point we hear a lot from researchers is the distinction between audit, clinical audit, quality improvement, and research. Please look at the resources in the National Ethics Advisory Committee guidelines. Here's a snippet from Table 1.2 of the guidelines. It does set out some considerations for you to review. I know it is quite complicated, so please reach out to your research office at Te Whāora Ora, or if you're at a university, reach out to your research ethics team and they can assist you with those determinations. I promise to demystify the ethics ecosystem in New Zealand, and the next few slides aim to do just that. Research ethics has developed over time to form a body of ethical rules and norms that researchers are required to comply with. And research ethics has a focus on the value and safeguard of participants, and more recently, groups to whom those participants belong. Now, why did research ethics develop? Some of you might know, but for those of you that don't, there's actually a long and unfortunate history of abuse of participants in research trials. From 1932 to 1972, experiments were conducted by the US Department of Health on 400 African American men without their consent, called the Tuskegee Syphilis Study. In Nazi Germany, there were brutal experiments conducted by Nazi scientists on concentration camp survivors, leading to war crime prosecutions called the Nuremberg trials, from which we get the Nuremberg Code. And in New Zealand, Dr. Herbert Green conducted experiments at National Women's Hospital on women with cervical cancer without their consent, resulting in patient deaths from delayed treatment. So research ethics has a pretty established body of rules and guidelines that all ethics committees follow. Up on the screen now are the four main principles of research ethics that are still in place and still in our National Ethics Advisory Committee guidelines. They are autonomy, beneficence, non-maleficence, and justice. Now, autonomy in research means that people have the right to make their own choices and decisions about whether they want to take part in a study. You must assume that everyone has the capacity to consent, and consent is the starting point in any discussion around the secondary use of data. Beneficence in research means doing things to help and protect the people who are taking part in the study. So you should make sure that your study is designed to bring good results and benefits to the participants. Beneficence also requires that projects have merit. Non-maleficence in research means not causing any harm to the people who are part of the study. You need to be careful and make sure that their study doesn't hurt the participants in any way. And you should take steps to minimize any risks or negative effects that could happen because of the research. And justice involves treating others equitably and distributing burden and benefits fairly. In other words, have a fair recruitment process. Don't put the burden of participation on some groups over others without being able to justify that to the ethics committee. Ensure that there's a fair distribution of and access to the benefits of the research in a timely and clear manner. And ensure that there's no exploitation of participants in the context of the study. Now, in New Zealand, we also have some unique principles called Te Aratika principles that were incorporated into the National Ethics Advisory Committee guidelines in 2019. Now, they exist in partnership with the other four principles that I've just said. And these are whakapapa, mana, tika, and manakitanga. Now, whakapapa refers to relationships, the quality of the relationships, and the structures or processes that have been established to support those. The relationship between researcher and participants, and in New Zealand this can include hapu, whānau, or iwi, must involve trust, respect, and integrity. Now, mana refers to power, prestige, and leadership, or authority bestowed, gained, or inherited. And that can be either individually or collectively. And it infers that participants have the right to determine their own destiny and their own authority. To respect mana, an ethics committee might determine that knowledge is shared between participants and the researcher, and any benefits are shared back to the community. Tika refers to what is right and what is good in any situation. Importantly, in the context of ethics, it relates to the design of the study and whether the research achieves its proposed outcomes, benefits the participants and communities, and brings about positive change. Tika also requires respectful relationships with Maori in all studies, regardless of the research design and methods. Manakitanga refers to caring for others nurturing relationships, and being careful in the way we treat others. Now, some of the traditional notions of research ethics are stretched when we apply them in the context of use of secondary data, particularly Indigenous data. I found this paper useful to assist my thinking around this, entitled Maori Data Sovereignty and Privacy, as it suggests to me further guidance and support for ethics committees could be beneficial as they navigate the issues of access to large data sets and the collective right to privacy. The paper identified a number of privacy issues for Maori arising from the status quo. A key concern was that the Privacy Act did not explicitly provide for the protection of privacy from Te Ao Māori perspectives. More specifically, it had an exclusive focus on personal information and personal privacy, thus excluding group collective information and privacy. It also does not explicitly recognise tikanga Māori or Māori concepts of privacy and does not have a te tiriti clause. Now, further directions, the conclusions of this paper were that privacy is both a fundamental human right and a gateway right that reinforces other rights, such as the right to non-discrimination and freedom of expression. Talked about big data technologies and practices that pose challenges and risks to individuals and collective privacy, particularly for marginalized and over-surveilled groups. While data privacy research standards and laws focus on the protection of individual data, personal data protection is part of a much wider set of data privacy considerations and Indigenous rights. Now, this is becoming an area where ethics committees would, I suspect, appreciate more guidance because it is becoming more difficult to determine who data is being shared with, what is behind some of the requests, and some of the complex commercialized entities involved in the applications, especially where there's a collaboration and innovation between university and commercial entities. Looking forward to advances in this area. I look forward rather to advances in this area that will engage further with this issue and what role, if any, ethics committees are expected to take when considering the waiver of consent provisions associated with the research exception in the Health Information Privacy Code. At the moment, the National Ethics Advisory Standards do contain a range of potential harms for research participants, and they range from the traditional physical harms up to the data harms. I've highlighted there the social or cultural harms. There is potential damage from secondary use of data from some data sets without consent to social networks and relationships, potential for discrimination and access to benefits and services, potential for social stigmatization, and loss of trust and harm to warua or mana. So the National Ethics Advisory Committee does have some guidance on this at the moment. I suspect that that might be strengthened in the refresh of the guidelines that we'll see coming out in the next few years. So at the moment, I'm going to turn now in the few slides that I have next to look at how ethics committees might respond when any researcher wants to use large amounts of existing data and bypass the need to gain consent. This waiver of consent, if in relation to health information, would be part of the hybrid approach to data security that I have outlined in previous slides. The National Ethics Advisory Committee will be revising its guidelines, as I have said, and an interesting argument has been suggested by Angela Ballantyne in 2018 article entitled Consent and the Ethical Duty to Participate in Health Data Research, which suggests an obligation to share data and make a case to expand in circumstances where secondary use of research, where secondary use of data, even with identifiable health information, is permitted without explicit subject consent. So we see that happening already in the current waiver of consent. That happens when there is a really good case for the public good of use of that information in that way, where there's transparency and ideally where there's public engagement around the parameters of that. So at the moment, gaining consent to use previously collected identifiable data should always be the default starting point. If you ask for a waiver of consent, you must justify to the Ethics Committee that you meet the threshold in Rule 7.47 of the National Ethics Advisory Standards. I'll put the specific rule there because the standards are hundreds of pages long. So please make note of that rule so you're not wading through them to find it. The Ethics Committee will consider the following: the potential benefits to individuals or wider public, the nature and degree of likely harms to individuals and or the public, the scientific, practical, or ethical reasons why consent cannot be obtained. It will want to review the data governance plans that are in place and increasingly asking for a data management plan. To what extent consultation has taken place by the research team with cultural or other groups, and whether these groups support the secondary use. Excuse me. If there's if there is any known reasons why the participant or group would not support the data being used, they should be told to the Ethics Committee and they'll be really interested in what they might be. So the last couple of slides, I want to go over the tips and the red flags to avoid. Ethics committees have experience in assessing applications and determining risk. So please be clear and concise in your application. They're seeing hundreds of applications a year, so they get pretty good at what they do. First thing is to reach out to the Ethics Committee support staff in your organisation early to assess the need for ethics approval. Facts matter. Small distinctions can tip a project from an audit to a quality improvement and on to research. Carefully consider if your project is going to use identifiable, that should be health information. Consider the potential for data to be identifiable through improvements in computational techniques, use of AI, and merging of data sets. Apologies for the typos in this. Consider the statistical purposes exception in Health Information Privacy Code and also the research exception. Make sure you use the right one, and once again seek guidance from your Ethics Committee support staff if needed. If applying to an Ethics Committee, make sure you can identify what data sets you want to use and can provide organisational permissions. If asking for a waiver of consent, use the list in Rule 7.47 of the NEAC standards to guide your answers. And please, please, please consider any conflicts of interest or dual roles you may have or members of your team may have and state these from the committee. Don't be frightened of stating them. In my experience, not declaring them is probably going to cause more delays in your application, as the ethics committee is pretty good at picking out when these might be. So it's better to just state them up front and allow the ethics committee to think of ways to navigate those conflicts with you in an ethical manner. Red flags to avoid: conflicts of interest not disclosed or mitigated. Commercialization not disclosed. Lack of data management plan to show how data will be transferred from an organization to the research team and at what stage the data will be de-identified. Researchers with dual roles who do not separate out clinical role from the research project role is always a red flag for the research ethics committees. And applications that ask for a wide range of data without justifying this in terms of research design. They're really just fishing exercises where people are putting in to get massive amounts of data, and it is apparent that they haven't quite worked out how they're going to manage that data or how it directly relates to their research design. Applications that seek to create an AI platform without being able to answer questions around AI are always problematic. We have new pre-screening questions which are being rolled out. One thing we will ask you is, what are you creating? Who is helping you create it? What is the platform for? It's not particularly helpful if at that stage it comes back with I don't know. We'll kind of develop it as we go on. There is an expectation that you can provide us with a certain level of understanding about what you're going to do and who's involved. I suggest in those instances to put an ethics application in phases or different stages so that you can start and then progress as you go along. A lack of engagement with Te Aratika principles and a failure to address issues of Maori data sovereignty will be a red flag for the committee as well. Now, areas of further clarification where I hope to do some more work and where I hope others will also join me in this and we can have further discussions is the weighing the public interest in research versus individual right to privacy. Further consideration of what the term not be published in a form that could reasonably be expected to identify the individual concerned means, because that is so important in the context of the Health Information Privacy Code. How to weigh issues of justice when health data from public health agencies is accessed for commercial gain and benefits may not be evenly distributed. If ethics committees are asked for a waiver of consent, further understanding of how this balancing is arrived at and if there is consistency across all ethics committees, and clarification for researchers on the division between statistical purposes and the research exception in the Health Information Privacy Code. So thank you for listening to my presentation. I hope that has given an oversight of research ethics committees, of the work that we do, of the role that they play in the Health Information Privacy Code and the releasing of data. And if there's any questions, I'm willing to take them for a few minutes. I think maybe someone at the Privacy Office can help me navigate that. If that's the case, I guess I might just conclude and thank everybody for joining me. And the slides will be available. And if anybody has any questions, please reach out to me. I'm very happy to answer them. And obviously, it's a topic of ongoing, I guess, oversight from many different people. And thank you for your time.